East, and good morning if you're way out west. My name is Aaron Lacey, and you are listening to the Higher Education Regulatory Outlook for 2025, which is brought to you by Thompson Coburn. Thompson Coburn, if you don't know us, is a law firm headquartered in St. Louis, Missouri, but we have offices all around the country. And we have a higher education practice within the law firm, which means we have a group of individuals who spend all or most of their time serving institutions of higher education. My name, I mentioned earlier, is Aaron. I'm one of the co-chairs of the practice and have been here for a very long time. I've been in the space now for almost 25 years, which is hard to imagine, and really focus my practice on the regulatory aspects of higher education. So that would be federal financial aid and accreditation and state authorization and all those kinds of things, which makes me well suited to talk about the regulatory outlook in higher ed. I want to take just a few minutes while folks are still joining us to go through our housekeeping. First of all, if you look there around your screen, you'll see the Q&A widgets. You can use the Q&A widget to ask us questions or to find answers to frequently asked questions. In addition, there is the resource widget, and the resource widget, you'll find inside of it the slides for the presentation. I'll also just offer up now, I know folks always appreciate when we make the slides available in advance. A lot of you complete surveys and have told us that. We do hear you, I promise. This presentation I've been updating on an almost hourly basis for reasons I suspect many of you can imagine. So I was not done with the slides and ready to pull the trigger until about 2 hours ago, which is why the slides were not available in advance. But they are in that resource widget. And if for some reason you are not able to find them or download them, just reach out to us because we certainly want you to be able to have them. The help widget is a place where you can go to find answers to technical questions if you need something comes up during the presentation. I do want to also, we have the Q&A widget. I want to go back to that and just mention, usually don't take questions during the presentation, but if you will go ahead and enter your questions at the end of the presentation, we're going to try to make sure we have time for some Q&A, and I'll try to go through those and get to as many of them as I can. Like almost all of our presentations, with rare exception, this is approved for continuing legal education credit. So if you are an attorney type, the presentation CLE accredited in California, Illinois, Texas for an hour and a half, in Missouri for 1.8 hours of general credit, and in New York for 1.5 hours of professional practice credit for experienced and transitional attorneys. I assume my New York brethren know what that means. Finally, we do always ask if folks have the time, please complete the survey that pops up at the end of the webinar. I've said it, I'll say it again. We take the survey responses very seriously. We always review them, and we are always interested in trying to make each presentation better than the one before. Couple of three other points here before we get started. One, and boy, this could not be any more true given the nature of this presentation. I just want to remind folks, laws and policies are updated regularly. If you are watching this on YouTube or a recorded basis after January 2025, please keep in mind that things may have changed. And I will just go ahead and offer here at the outset, we are expecting potentially that a couple of, we're hearing rumblings that a couple of executive orders may land even during this presentation. If that happens, I have some folks who are going to help try to pull that together and get me information live so we can try to talk about it because we think they could be impactful for the community. Live links. So in the PDF itself, there are many links. That's what you'll get in the resources widget. So you can't, if you're on YouTube, you can't click them on the screen. But if you download the PDF, the links in the PDF are live and will take you to a lot of the underlying resources, court decisions, things that we are referencing. Finally, I also want to note, we have, you'll see towards the end of the presentation, I'll go very quickly through our TC Extra Credit materials. They're all free. And they are all now accessible in one place on our higher education resources page. And there is a magical QR code here right in front of you. If you scan that with your phone, it'll take you right to our higher ed resources page. And that in turn can take you to our blogs and our compliance resources and our various webinars and training series. Again, all of which are free and are there for you and hopefully you find useful. Here's our syllabus for today. Want to talk just briefly, we're really focused on the regulatory outlook and what's going on at the Department of Ed, I'll say sort of down in the executive branch, right? But I did want to start just with a couple of slides talking about what's going on in higher education in Congress. Then we're going to talk about the state of the U.S. Department of Education. And I mean like what state the agency is in, because when you talk about the regulatory outlook. It's not just about the policies that we may see in the coming months and years. It's also about who is there to try to execute on these new policies, on the mechanics over at the department, et cetera. And candidly, I think that may be more impactful when you think about what, as an institution, your regulatory experience is going to be over the next 3 or 4 years. More of it may actually come down to the staffing and resources and capabilities at the department than even the policy direction that the department is taking. But then we will pivot from there. We'll talk about new personnel and priorities, the status of the Biden administration's Title IV rulemaking agenda, because we just had all these new rules that came along, and we want to talk about sort of where they are and where we think they're going to land in the coming months and years. We'll talk briefly. I'm going to take a deeper dive on the bar defense to repayment and financial value transparency and gainful employment rules. Then I want to hit just a few additional rules there in court. Finally, you will see here on your syllabus there at the bottom in blue, it says Appendix A, significant ed regulations effective July 1st, 2024, and not presently challenged, meaning not presently challenged in court. We have an entire appendix to this presentation that goes through those regulations that I'm not going to cover today. But I'm going to talk about them a little bit. And, you know, as I was putting together the presentation, I thought I'm going to mention all of these things, and folks are going to say, well, I may not be familiar with those, or what is he talking about? So we had done a presentation about a year ago, right around when these regulations took effect. We never did it on our platform. We did it elsewhere out in the world. And we thought, you know what, we're going to take those slides because they got a lot of really good content about rules that are in effect today and not under challenge. And we're going to just throw them into this appendix. So again, I'm not going to talk about them, but please go to the resources widget and download that PDF so you'll have that additional appendix there and you can go through those at your convenience. Okay, so let's start up on the hill. Later we'll go down in the valley, but let's start up on the hill and talk about higher education in Congress. I'll just note my the chair of our lobbying and policy practice, Chris Murray, who's a higher education guy as well, helped me put this together because he is more in tune with what's going on the Hill than just about anybody I know. He's also one of the folks who's keeping an eye out for that executive order for me right now. So historically, the HEA, many of you know, has been authorized every 4 to 6 years, that meaning since 1965 moving forward. But the most recent authorization occurred in 2008, so almost 17 years ago. It's been a long stretch. So we went from every 4 to 6 years, then it got to 8, and now it's been 17. And as you guys, I'm sure, appreciate, this is just emblematic of the sort of dysfunction we have in Congress. I don't have it in this presentation, but I used to have a presentation that showed that back in the 80s and moving into the 90s, about 6% of all legislation that was introduced became law, and now it's down to 2%, maybe less. So Congress is having a harder time. There have been some things, even on a bipartisan basis, that have been accomplished in recent years, but generally speaking, Congress is less efficient, and clearly in the higher education space, we have not been getting direction from Congress or a wholesale sort of reevaluation of the higher education framework. As of January 2025, of course, I'm sure the folks on the line know, the Republican Party controls the House, the Senate, and the White House, and will continue to control the legislative and executive branches for at least the next 2 years, right, until the midterm elections. But, and some of you may appreciate this, to others it may seem counterintuitive, especially with the thin majorities, meaning they're, you know, the Republicans just barely have the majority in both the House and the Senate, especially with those thin majorities. We really don't anticipate a comprehensive reauthorization of the HEA anytime soon. In fact, any kind of legislation, right, to get through, every Republican is going to have to be on board. It only takes a handful of Republicans dissenting on a particular direction or piece of legislation to keep it potentially from getting through. And so we think, we find it hard to believe that there's going to be so much consensus around the direction of the HEA that we would get to a reauthorization. That having been said, we do anticipate some partial HEA reauthorization efforts utilizing the budget reconciliation process, which can include provisions that have been previewed already in the College Cost Reduction Act, which was the sort of most recent piece of legislation that the Republicans advanced to reauthorize the HEA. Also noteworthy, the Republicans might use proposed changes to the Title IV programs, meaning the amount of loans, et cetera, such as limiting regulatory authority of the department, reducing student loan borrowing limits, which I just mentioned, and introducing a risk-sharing system, largely as cost-saving measures to offset other things that they're trying to advance, like their extension of the 2017 tax cuts. I do want to take just a minute. You know, we highlighted risk sharing here, and I wanted to highlight a couple of conceptual ideas. I mean, one is, generally speaking, sometimes I think that there is, the Democrats have had a lot of interest in accountability systems, particularly at the U.S. Department of Education in the last 20 years. Gainful employment is a great example of this. That's the financial value transparency and gainful employment rule. The Republicans have pushed back against that rule, but I think it's a little bit of a false narrative to suggest that Republicans aren't interested in accountability. To the contrary, they are pretty interested in accountability concepts, and just different ones, and sort of the ideas about how they want to approach that accountability can be different from the Democrats. But risk sharing is something that they have been very interested in and talked about for the last, really 15 to 20 years. And what we're talking about here is, for example, a system where institutions, you might calculate a repayment rate across institutions of higher education in the United States. And if your repayment rate exceeds a certain level, or cohort default rate exceeds a certain level, the institution might be able to be required to actually cover some portion of those defaults, or in the repayment context, find some amount. So the notion is, what Congress is playing around with is this idea that if you're an institution where lots of our loans are getting defaulted or not repaid, then you should have to pay us back a little bit, in other words. And that risk sharing idea has been floated quite a bit at the congressional level. Okay. So now let's move on to the U.S. Department of Education. And I mentioned earlier, and I really think this is important, I think a big part of what your regulatory experience is going to be like over the next 3 to 4 years is going to have less to do with the policy direction at the department and more to do with the resources available at the department. And it's really important to understand, even as this administration comes in, you're already dealing with an agency that is really severely depleted, and I'm going to talk about this in a minute, but demonstrably demoralized. So while the department over the last 20 years, really starting with sort of the first part and into the second part of the Obama administration, and in every subsequent administration since, and I know I'm preaching to the proverbial choir here, we've had this regulatory whiplash. We've had this huge sort of uptick in the revising, rescinding, and resurrecting of these massive regulatory frameworks. We've had almost constant rulemaking. Of course, you as institutions have had to try to absorb that and understand it, and then try to train people. You've rewritten your policies, et cetera, whether that's Title IX or, gainful employment and data reporting, or just the wide range of different types of rules and regulations that you contend with. Since 2000, while at the same time we've had this uptick in regulatory activity and the constant rewriting and the additional rulemakings and all the trainings and everything that has to come along with that, you've had fewer staff overall at the department. So there's been this sort of constant reduction. In about 2000, you had about 5,000 people at the U.S. Department of Education. Today, it's about 4,300. During the first Trump administration, at one point, it got as low as 3,600. But overall, you've had a sort of a consistent decline in the number of hands on deck at the department. Also, and this is really critically important, it's not just about the number of people, it's also about the experience of those people. There's been, as we have recognized, and I think others in the space have recognized, a real loss of institutional knowledge at the department. And that is in part just due to baby boomer retirements, as well as folks, like the Republican Party being interested in shrinking the Department of Education, the Democrats being unable to get or secure additional funding to hire more people, generally speaking. All of this, as a consequence, we've seen sort of this loss and reduction of folks and hands on deck. And there have been a lot of individuals, particularly over the last 10 years, who were at the department for 20 or 25 years and had a really deep understanding of the financial aid programs and the history at the department and how certain processes were run, who aren't there anymore. And there are folks now sort of leading divisions who are not as prepared or just don't have as much experience. We've chatted with folks in the last year who've referred to, I had someone say, Aaron, and this is someone at the department who told me, it's skeleton crews over here. Just everywhere you look, it's skeleton crews. So they already feel like they are significantly diminished and under-resourced. Not surprisingly, this combination of increased responsibility, decreased capability, and constant change has had a really negative impact on the agency and its morale. Some of you may know this, but every year the federal government does a survey throughout all of different agencies, and they've been doing it for almost 20, 25 years now. It's called the Federal Employee Viewpoint Survey, and there's another organization, the Nonprofit Partnership for Public Service, that compiles all those results and puts out what it calls the best places to work in the federal government. I've got the link here. It's pretty interesting stuff. You can go check it out. But since 2003, the salient point here is the Department of Education has consistently ranked at or near the bottom of the mid-sized federal agency rankings. And I pulled this together the other day. I was looking at it, and it's really fairly extraordinary. If you look, so where you've got a red box, if you look at the top here, we start in 2010, right? 11, 12, 13. Then you go down to the second row all the way through 2023. So we've got about a 13-year history here, right? And then you've got the engagement and satisfaction score that came out of that survey. And underneath that, it tells you where the department ranked relative to all the other agencies sort of in that class of mid-level agencies. If it's red, that means they were in the bottom 25%. If it's yellow, that means they were below the 50% mark. Now, what you can see and what's interesting here is the whole top row. So you're talking from 2010 to 2016, that's your Obama administration. And then you've got the Trump administrations, so sort of the Trump one, the first four here on the second row. And then we've got 2020, 21, 22, and 23. But what you can see is across that entire 13-year period, the department has been in the bottom 25% pretty consistently. There have only been 4 years where they even got into the, that 25 to 50% quadrant, right? And if you look during 2018 and 2019, which is sort of the middle of Trump 1, the department was dead last. Look at that bottom row, 27 out of 27, 25 out of 25. So we're talking about an agency that is not just, I'll say like less than good. I mean, we're talking about dead last in the entire category. So it does look like here in 22 and 23, the department has been ticking up, at least in the last couple of years of the survey. And you see in 2023, they got to 68.8. But check this out. So this is an excerpt from the survey in 2023. So this is from the best year that the department scored out of the entire last 13 years, right out of that survey. My workload is reasonable. 30% said yes. So 70% said no. The approval process in my organization allows timely delivery of my work. 70% said no, 30% said yes, right? I believe the results of this survey will be used to make my agency a better place to work. Only 27% said yes. Management involves employees in decisions that affect their work. Only 27% said yes. In my organization, senior leaders generate high levels of motivation and commitment in the workforce. 24% said yes. And keep in mind, over the last 13 years, this is from the best year on record from this agency. These were the results they got in the survey. So, the message here is this administration is coming in and taking over an agency that is already in greatly challenged, right? And there is nothing we are seeing in the proverbial tea leaves that suggests that this is going to get any better, and that the resource constraints and that the stress and frustrations of the folks at the department that are already there, that's going to somehow alleviate or relieve that. So on January 20, Trump's executive order directed all federal employees, as I'm sure most of you know, to return to in-person work on a full-time basis, and expanded the president's ability to terminate certain federal employees if they're grouped into that sort of appointee class. On January 28th, in an email to federal employees, some of you may have seen this was just 2-3 days ago, OPM, Office of Personnel Management, observed that the majority of federal agencies are likely to be downsized through restructurings, realignments, and reductions in force, and unveiled the buyout or deferred resignation program. So we're talking about an agency that is already greatly challenged, that is likely to be further reduced, and where, there are fewer people who have institutional knowledge and capability, and those folks all are being offered the opportunity to potentially resign or leave. So we believe, as you would probably imagine, that there is significant risk that the department will become even further depleted and demoralized. In fact, and I haven't seen it yet, but the rumblings we're hearing is that there may be an executive order that hits, while we're presenting here in the next hour or two, that might go further and actually direct the department specifically to reduce itself, if not to the maximum, greatly. So, and I don't know that would be a surprise. Really, the Trump administration has already signaled, certainly during the campaign and even now in these initial executive orders, that they want to significantly winnow down and reduce the size of the federal government, as specifically at the U.S. Department of Education. We anticipate that extended timeframes for approvals of programs, locations, mergers and acquisition, and all these other types of requests and functions that you have to go through the department to complete are just going to become further extended or be equally difficult. And that's even if, cutting in the other direction, theoretically, if the scope of responsibilities at the department were to be significantly reduced, let's say there's no gainful employment, there's no bar defense claims to go through. I mean, you could take a lot of things off the plate. And even theoretically, if leadership were to come in and be very strong and very positive, and I know people have very different ideas about, this administration and the folks who are coming in, et cetera. But let's just say, let's say leadership is great and strong and encouraging and positive. Even if those things are true, we think that you're going to be dealing with an agency that is severely depleted, and it's going to be greatly challenging. And by the way, this is what we saw during the first Trump administration. We saw policies that moved in a direction that frequently were more favorable to institutions or reasonable to institutions, just meaning a rewriting of things like bar defense or the financial responsibility reporting requirements that were a little more reasonable, reduce the burden on schools. And generally, like I said, most institutions looked at in a way that was favorable. But at the same time, it really was with the beginning of the first Trump administration, when the employees at the department, remember, went from 5,000 all the way down to 3,600, that we started seeing timelines significantly extended for processes that used to take 2 or 3 months. Then we're taking a year or a year and a half. And then, unfortunately, even with the Biden administration and some uptick in employees on hand, we saw those timelines get even further extended. There are no indicators available to us right now that suggest that trend is going to change. And in fact, the indicators available to us, like you see on your screen, suggest that things are going to become harder and harder to accomplish. I certainly hope I'm wrong. We've been talking about this internally. It is our great hope that we are proven to be speaking out of turn here, and that leadership will be strong, scope of responsibilities will be reduced, functions and mechanisms will become more efficient. But right now, it is difficult to see that happening. So I'm hopeful I'm wrong, but it is difficult to see that happening. Another thing that's really complicating all of these efforts is not just the hands on deck, but as you all know, or many of you certainly know, the significant issues with the FAFSA and the EAP. I know some of you, everyone, I should say, just about is familiar with the FAFSA. That's been front page news in some cases. The electronic application system that schools use to supply applications and change certain things, there are fewer people at an institution that deal with that. Federal financial aid does. I think general counsel are spending a little more time with it, particularly as the department's been asking for data about board members and owners, et cetera. That system also has been experiencing significant challenges. And the problem we have there is, you have subcontractors who came in and built those systems, and the staff personnel at the department who did not build those systems are getting all the questions, but have limited ability to try to answer those questions. I know many of them are as frustrated as institutions are in trying to manage these new systems, but that just further complicates and frustrates, institutional efforts to get things through the department and to get them approved and moving on. This brings us to our first secret word. And if you'll look, there are 3 on the screen right now. The first secret word is Outlook, which is item C. So if you have a minute, particularly if you're an attorney type hoping to get CLE credit, please take a moment to click on C. And also, while you're doing that, I'll just take a deep breath here and say, look, I know this is a time of transition, whether you are a proponent of or opponent of or neutral with regard to the incoming administration. It is definitely a time of transition and change. And I know for institutions, anytime there's transition, it creates anxiety in almost any circumstance or context, right? So I expect there's great anxiety among institutions right now, without regard potentially to your political or ideological beliefs. And I know that when, you've just heard me talk about all the sort of the outlook for the department and the state of the department, it is not encouraging. But I do want to take a second while you're answering the survey to just say, thank you for what you are doing. Without regard to the challenges and the transitions that, that higher ed may be going through right now or is going through right now, there is no question in my mind that our system of higher education in the United States is extraordinary. I think it is fair to say, or at least arguably true, that it is the envy of the world. And what you all are doing every day in supporting this is truly changing lives and changing society, right? So I thank you for that. I know this can be tough to watch, these types of presentations. but also want to just offer a word of encouragement, and that we really appreciate Thompson Coburn, and I know all the folks who support higher education do what you are doing every day with regard to your mission in educating and helping folks change their lives and advance and go out and do productive things. So thank you for that. And I hope that will be at least a little bit of an antidote to the more challenging discussion here around transition and what we may or may not know about the future. Okay, so we talked about the challenges at the department and what we're likely to see there. But then, there's this question of, okay, well, who is coming into the department and what do we know about them and the folks that we hope will actually lead the agency to efficiency and success? So first of all, it's worth noting with Congress largely sidelined or being less efficient in recent years, what we've seen is administrations advancing their education policy through the executive agencies, right? And that includes through rulemaking and enforcement actions and sub-regulatory work as well, meaning dear colleague letters, electronic announcements, all those kinds of things. And we don't think that's going to stop being the case. I mean, even if the Department of Education is deeply reduced, there are still policy priorities that this administration has in the area of education and higher education, and they're going to be channels through which they want to carry out those policies one way or another. And we think that's going to continue to happen through the executive agencies. In fact, we've clearly seen that this administration is exercising executive authority in ways that there's sort of been a consistent trend over the last 20 years in increased executive authority and activity, right? And this administration certainly is not proving to be an exception to that trend, right? So we fully expect to continue to see a lot of activity in the way of executive orders, rulemakings, sub-regulatory activity, et cetera. Your new secretary to be still not, confirmation still not scheduled. We understand there's still just some information that's being exchanged, et cetera. But we anticipate Linda McMahon will be confirmed as the secretary. Most of you probably know, formerly the CEO of the WWE, also spent 2 years at the Small Business Administration. So does have experience leading complex organizations. Not a lot of prior education experience, a little bit, briefly sat on the Connecticut Board of Education, and has been a longtime trustee actually at Sacred Heart University. What is interesting here, I'm sure some folks are aware of this, but historically with former Secretary and Senator Lamar Alexander being the exception, it has been the case that most of our secretaries of education over the last 20, 30 years, their background, to the extent it's been in education, has been elementary and secondary. And what is interesting is here, while there's not a lot of experience, the experience that Linda McMahon does have is in higher education. And I think, and we're going to see here with some of the appointments that are general appointments to the department, that continues to be true, which suggests that this White House actually may be a little more focused on higher education, even than elementary and secondary, which historically was sort of the headliner. In case you don't know, Denise Carter is currently serving as acting secretary, so you may see her name. She's been the chief operating officer at FSA since July of last year, and previously served in a number of capacities at FSA under the Biden administration. So is still there, keeping things moving while Linda McMahon is waiting to be confirmed. And we do expect that she will be confirmed. So senior staff, we had hoped for a couple more announcements by today in this presentation. We haven't seen them yet. But the department has made some announcements about senior level appointees. I'll note we still don't know who's going to be in a couple of, or more than a couple, but some of the more prominent key spots for higher education, undersecretary, chief operating officer of FSA, for example. We've heard very strong rumblings about who those persons might be. I will tell you, I mean, the names that we have heard are folks who, as you would expect, sort of ideologically, are on the Republican right side of the House, but they do have significant experience in higher education, or, particularly with an institutional perspective, have worked with, in, for, or represented institutions of higher education, which suggests to us that the policy direction coming out of this administration would be, I won't say more favorable to institutions. I feel like that's sort of a mischaracterization, but more reasonable, perceived as more reasonable by institutions. But nothing we've heard is surprising. Here are just a handful of the appointees we have seen so far. I highlight these when I say not surprising. So, for example, Linda McMahon the last few years has actually been at AFPI, which is a right of center think tank. So two of the senior folks are chief of staff and also the deputy chief of staff for policy and programs, both coming out of AFPI, so individuals she has worked with before. But interestingly enough, in their roles at AFPI, and this is what I was noting a second ago, both were sort of working with post-secondary considerations or at that level. They're not elementary, secondary folks. So again, interesting to me that both your incoming secretary, chief of staff, deputy chief of staff for policy and programs, all to the extent they have experience in education, it seems to be primarily in higher education or post-secondary education, which again sort of signals a shift just generally at the department in the interest and affairs of higher education versus elementary and secondary. Craig Traynor, Deputy Assistant Secretary for Policy, Office of Civil Rights, is coming over. He was serving as Senior Special Counsel in the House Judiciary Committee previously. And then Candace Jackson, a name many of you will probably recognize, back as Deputy General Counsel, served in the first Trump administration as Acting Assistant Secretary for Civil Rights. So let's talk about, at a high level, sort of where we see higher education policy priorities for this incoming administration. And what I've done here, a couple of things for you to consider. First is, in my mind, I anticipate that many of the policy priorities over the next 2-3 years will fit into one of a couple of different categories or buckets, whatever metaphor you like to use. You know, with the Biden administration, a lot of what we saw could either be put into loan discharge and forgiveness or sort of accountability, consumer protection, right? So you think about, you know, all the efforts to forgive loans, the rewriting of the post-school loan discharge, bar defense discharge, you know, all those types of things, false certification discharge rules. And then on either side of the house, you had, you know, financial value transparency and gainful employment, and a lot of the changes to administrative capability and financial responsibility, which are about, you know, accountability measures and consumer protection, the aggressive and recruiting rules, for example. So with this administration, I'm sort of, for me anyway, conceptualizing a lot of these things in two different categories. One I'll call culture wars, for lack of a better phrase, and the other I'll call regulatory reduction. And I've taken the bullets you see here come from one of two places. One is these are statements, comments that President Trump made during the campaign and more recently. Also, some of these bullets, if you actually go to AFPI's website, and I mentioned it here at the bottom, you could Google America First nomination. That's AFPI, American First nomination, Linda McMahon. It'll bring up that website, and it's actually got on the page a list of educational issues, higher ed and elementary, secondary, that she supports and opposes. So you do get some sense as to what her stance is with regard to a lot of different education issues. If you want to Google that, take a look. So I've incorporated some of those as well. If you look on the culture war side, you know, increased scrutiny of and taxes on elite institutions, right? Clearly a focus of the incoming administration. Excluding sexual orientation, gender identity from Title IX. We've already seen that executive order. Limiting DEI efforts and unpatriotic education. Again, we've seen that action on that already. Limiting student activism, anti-Semitism on campus. Protecting free speech for conservative students and faculty, and revising the role of accreditors, which you could see as not so much a culture war issue, though I expect that some of what this administration is going to try to do through the revision of its regulations governing accreditors will be at, it will get at DEI and some of these other sort of culture war type issues. And the other side of things, you've got regulatory reduction. And I don't mean reducing the number of employees at the department. I mean reducing the number of regulatory frameworks with which institutions have to contend, right? So we're really talking about regulation, policy, sub-regulatory guidance at this point. Dismantling or reducing the Department of Education, reducing federal education bureaucracy, restoring state control of education, eliminating government overreach. My guess is, and this isn't, to be very clear, not a political statement, I just mean from the standpoint of institutions that have to contend with these transitions and changes. My expectation is most of what you see on the culture war side for many institutions will create work challenges, right? The changes that are going to impact you in a way that is going to require you, it's going to increase your burden. I'll put it that way, right? Whether you are ideologically in favor of it or not, et cetera, these are changes that are going to require action on campus, right? And a lot of thought, et cetera. There stuff in the regulatory reduction bucket, on the other hand, I think much of that will reduce the amount of work for institutions. Now, where we're talking about delayed approval processes and things like that, that's not what I mean. But what I mean is the elimination of, you know, financial value transparency and gainful employment, for example, produces a lot of work for institutions of higher education. So in many respects, I think that this policy agenda is, at least if you're just talking about sort of the work created for institutions, a mixed bag. I think there will be things that are done that are going to require more work and create challenges for a lot of institutions on campus. And then I think there are going to be things that are done that candidly institutions will welcome and will reduce the amount of work and data collection, et cetera. Okay, let's talk about speed to implementation. So you've got all these sort of competing policy priorities. We feel like the new administration's plans for the formal revision and rescission of regulations will probably unfold later this year, right? So, and that's historically what we've seen. We don't see any reason for that to change. Right now, they're circling the wagons. People are being appointed. They're going to have to sort of decide what their policy agenda is going to be. And then on a go-forward basis, to the extent that they're going to try to do things through formal rulemaking, launch negotiated rulemaking processes, et cetera. To the extent you've got Title IV rules that are subject to negotiated rulemaking, keep in mind, I mean, outside of an extraordinary pace, what we would typically expect is to see those negotiated rulemakings launched later this year, held throughout next year with final rules by November 1st of 2026, which means that those rules become effective at earliest July 1st, 2027. So when you're talking about the revision or rescission of formal rules that are on the books, you're talking about almost a 2-year process, right? On the other hand, we think a lot, and that's a lot of the stuff we think, if I went back to that prior screen, that's in the regulatory reduction and reform bucket, right? But the stuff in the culture wars bucket, as we're already seeing, I think I put this slide together a few executive orders back, but we anticipate that this administration is going to move very quickly to try to push these through, and we're already seeing that, right? As has been widely reported, the Trump administration already has issued multiple executive orders that are impacting higher education. I'll talk about just a few of them right now, although, I want to make sure to leave time to talk about some bigger policy direction and things like that, some of these Title IV rules. And I know a lot of you have been reading the news every day and trying to keep up on all these executive orders. But just to hit a few of them with a few thoughts. The regulatory freeze executive order, keep in mind the Biden administration had one of these. The prior Trump administration had one of these. This is not a new thing. The notion is when a new administration, at least it's not new in the last 15 to 20 years, the idea is when a new administration comes in, to the extent you've got regulations or policy in the pipeline that has not yet taken effect or been published, they're saying, stop everything. We don't want policies or regulations that were created under the prior administration to go live or take effect until we've had an opportunity to review them. So that's what's occurring here. But I do want to highlight a couple of things. While this directive has no impact on existing regulations, that would be that have already become effective, like financial value transparency, borrower defense, it could impact the new distance education and R2T4 rules. Because remember, those just got issued in final form and are not slated to take effect until July 1, 2026. So they are exactly the kind of rules in the pipeline that this type of order is designed to freeze and to give the incoming administration or the new administration more time to be thoughtful about. Title IX. So the new Title IX executive order, it's what I'm calling it. It's got a different title, but I'm just keeping it simple. Directs the Attorney General to issue guidance stating that Title IX does not require gender identity-based access to single-sex spaces, and instructs the department to rescind its 2021 guidance, which goes, a fair ways back, that extended Title IX protections to include sexual orientation and gender identity. This having been said, as most of you, I assume, know, on January 9th, a federal judge from the Eastern District of Kentucky, and this is the smaller bullet here, vacated the Biden administration's 2024 Title IX rule, which effectively took it off the books. And actually, today, this morning, if you go and look at the news, the U.S. Department of Education's press release page, the department issued a new Dear Colleague confirming its intent to enforce the 2020 rule. So, even before the executive order was signed, at least in the case of the January 9 decision, and certainly now in the wake of the Dear Colleague, our expectation is that the 2024 rules is essentially taken off the books, and probably permanently, right? And our expectation is institutions are moving towards reinstituting, if they ever moved away from the 2020 rule, or if they did, now moving back to implementing and instituting that 2020 rule, which just briefly, most of the schools we work with, not all, but many, under the 2020 construct, they sort of had the Title IX processes and procedures with the understanding that there could be issues that arose, discrimination on the basis of gender, for example, or sexual orientation, that had to be excluded from the Title IX consideration. But then they had either a mirror or similar alternative structure for managing sex discrimination on the basis of gender identity or sexual orientation or other things that might have occurred outside the scope of the 2020 definition of Title IX sexual harassment under that alternative process. So our expectation is at this point, most schools, and if you've not thought about this, our expectation is most schools are going to go back to those sort of alternative path policies where they'll manage Title IX sexual harassment under the 2020 rules definitions under that Title IX policy. And then to the extent you may be required by state law or municipal law, or just decide to have a more expansive policy to address discrimination on the basis of gender identity, sexual orientation, et cetera, you would manage that under that policy. The DEI executive order, again, I'm sure many of you on campuses have already spent hours thinking about this. You've looked at you may have watched the NACUA, had a briefing. There are other folks who put out very good resources. Directs federal agencies to eliminate race and gender-focused programs, redefine sex as strictly binary under federal laws, and place all diversity staff on paid leave ahead of planned layoffs. It also directs fed agencies to inform grantees and contractors that they must cease and desist all DEI work related to the grant or contract. And there are more implications as well. There's forthcoming guidance around what this means in the context of students for fair admissions, Harvard University versus Harvard University. And then finally, there's sort of this suggestion threat that a number of very large, well-endowed institutions may be identified and investigated, right? Couple of things to note here. I don't want to spend too much time on it because, again, I think a lot of you have probably spent a lot of time thinking about this. If you want to call us, we've got lots of folks who've been working with our clients and other institutions on this particular executive order. But for purposes of this presentation, the two things I'll note is, first of all, my colleague Scott Goldschmidt, who was actually quoted in the Wall Street Journal today, congratulations, Scott, made the point, and I agree, that there are a number of states that already have at the state level taken measures to outlaw or prohibit certain types of DEI activity, not unlike this new executive order. And to those of you who aren't in those states, it might be worth reaching out to your colleagues in those states to talk about how they have managed to advance their priorities and mission, notwithstanding or in compliance with those state level laws. So I just want to highlight here, there are other institutions around the country that have already sort of been managing this type of restriction. In some cases very successfully, including here in Missouri, where I'm sitting. So if you've got colleagues, that's a good resource because they have already been dealing with this and thinking about it a great deal. And then apart from that, I just also want to highlight that these executive orders very much are impacting agencies. And, maybe that seems obvious, but in very real ways and immediately. So the department had a press release right away on January 23rd announcing steps to eliminate its DEI initiatives, including those impacting institutions. They removed internal, external DEI policies and guidance, closed offices focused on DEI matters, and they've already indicated that they're going to continue sort of a comprehensive review. They also, if you go to the page for press releases for the department, have already launched an investigation or two focused specifically on advancing these DEI priorities under this administration. And then there's the grant and loan pause, which was very exciting this week for those of us in the space, to put it mildly. And hold on, I'm getting a text. I just want to see. Okay, so it looks like the executive order I mentioned earlier that may impact higher education priorities and the U.S. Department of Education may not come out today, but we understand there is something in the mix, so keep an eye out for that. I'll just leave it at that. So the grant and loan pause, very exciting earlier this week. I won't go through everything again, but on January 27th, we had the memo directing the federal government to essentially pause temporarily all the grant and loan programs. And then there were all these questions about, well, what's the scope of the pause? On January 28th, U.S. District Judge Lauren Ali Khan blocked the pause, and then a day later, the administration rescinded its own pause, right? But I wanted to just acknowledge that, a big part of the challenge for folks, even apart from, we're going to take a step back from all of this in a second. We're going to start talking less about the stuff that's happened in the last 2 weeks and more about sort of the big picture the rules and regulations that are out there and where we think things are going. But the fact of the matter is, we do have these executive orders coming across the transom. We've got, all of you can have more memos, things like that. All we can really suggest and advise is, when this happens, take a beat, get with the right people in your organization. If you've got outside counsel, if you're our client, you're obviously welcome to call us. We are always trying to keep up with all of these things and be thoughtful about them. But I also just wanted to encourage folks, if you're in a trade association, all of the trade associations I'll say all, and many of them even a step further, have been doing great work in tracking much of this. I'll give a shout out to the American Council on Education. They had a very nice page where they sort of summarized all of the executive orders. But I've seen excellent materials from everybody here on your screen, just to be very clear. Also, there are some trade associations that don't represent institutions, but represent particular constituencies within institutions. So I'm talking about NACUA, which has a very good webpage right now. It always does. I think it is behind a paywall, most of it. But for all of you who are members of NACUA, it's obviously a great resource. They had a really excellent briefing they did just a couple of days ago. NASFA also, for the financial aid folks, always does very good work as well. And I would, if you don't have the USCD newsroom up on your browser right now as a favorite, highly recommend that you put it there. And boy, I would just check it twice a day right now, because a lot of the press releases, the executive orders, things that reflect on higher education are popping up there. But all this is just to say, it's a time of great transition. Things are moving very quickly. And of course, there are the news outlets like Inside Higher Ed, The Chronicle, Politico Pro. If you don't sign up for those guys, are certainly worth following. But then I think the trade associations also do very good work sort of absorbing the news and then trying to do a level of analysis and processing for their particular members and constituencies. And then you've got the folks like NACUA and NASFA who may be reflecting sort of the views of their particular constituencies within institutions of higher education. To the extent they have listservs, automatic emails, daily things, I just recommend that you try to sign up for the ones that you think make sense. And then scan those on a daily basis. Take those beats when things come in, get the right people at your organization together to talk about them. If you need to, reach out to these folks. And also just keep in mind that other piece of advice. As some of these things happen, there are some states where schools have already been dealing with similar restrictions. It was the same thing with admissions, sort of race and admissions. There were a number of states, even prior to last year's decision, the Harvard decision, where that essentially a similar restriction was already on the books, right? So highly recommend thinking about reaching out to some of those colleagues and understanding the approach that they've taken to manage these types of requirements. Okay. So let's take a step back from the last 20 days exactly, and let's talk about all these new rules and regulations that came along over the last 4 years and where they are and where we think they're going to go. And I want to stress, I think it is very easy when you are in a period like we are in right now. I just finished telling you, go to the press, the news, watch all the press releases in the newsroom, and you have to do that, right? You can't ignore these executive orders because they're obviously impactful and important. But it is easy to allocate all of your time to the thing that's just hit your email, right? And there are a lot of other things that are out there that are important to be thoughtful about, that have not gone away and that aren't being challenged in court and are not being impacted, at least right away, by any of this activity that we're seeing. And I just want to make sure we talk through that and that we think about where those things are heading in the coming months and years. So just a reminder, there was a whole lot of rulemaking activity under the Biden administration, right? As if you need a reminder. What I've done here and on the next two slides is I've laid out by effective date and sort of categorically speaking, the big rule packages that came through. And you'll see at top, that's a live link. So that'll take you to the actual Federal Register, right? And then it shows sort of from a topic perspective, the topics that were covered in that particular Federal Register. So effective July 1st, 2023, we had new rules governing change in ownership processes, Pell Grants for prison programs in 9010. We've got bar defense, and then we've got a whole package of revisions around loan discharge, closed school, total permanent disability, false certification, right? Pre-dispute arbitration and class action waivers was addressed in that July 1, 2023 rule package, as was public service loan forgiveness. Now, I want to highlight here at the bottom, the stuff in red is subject to a current legal challenge, and I'm going to spend a little more time talking about that. But I also want to highlight how much on your screen is not in red, right? All of these rules, which were extraordinarily complex and impactful, are still on the books. And there's nothing we've seen so far that suggests that they're going to be eliminated anytime soon. I mentioned earlier, I mean, these are actual laws that were created pursuant to the Administrative Procedures Process, Act and negotiated rulemaking, et cetera. And it's going to take a formal rulemaking to get them formally off the books. Now, there can be some slow walking, things like that. We'll talk about that in a minute. But I just want to emphasize there's a whole lot that's out there that is not going away. And you may say, Aaron, why are you beating this horse or this dead horse? Maybe not the best metaphor. I need to come up with a new one. Why are you hitting this topic over and over? It's because we have clients who call us all the time who sort of had this idea that there's been a change in the administration and now all this stuff is done and it's gone. And it does not work that way, right? And it's important for you all at institutions who are responsible for complying with all of these rules and regulations to appreciate that they could be on the books for 2 more years. Some of them may never go away. And, those of you who listen to me or have heard me speak, have heard me say this before, it's a real false narrative in my mind that, the Obama administration created a bunch of rules and the Trump administration just rescinded all of them and the Biden administration put them all back. That is really not what happened. And you'll see that in the press sometimes as the narrative. The truth is, outside of gainful employment and that framework, most of the regulatory packages that the Obama administration put in place were revised by the Trump administration. Bar defense, financial responsibility reporting, et cetera. And in many cases, they were made, I think, from an institutional perspective, more reasonable for institutions, but they didn't get rid of them. The Obama administration introduced for the first time this idea of financial responsibility reporting and financial triggers. And the Trump one did not get rid of that framework. They left it. They just reduced it a little bit, right? And focused it differently. But the rules stayed on the books. And under Title IX, as many of you know, it was actually the Trump administration that promulgated the first big rule or set of regulations around managing allegations of sexual misconduct on campus. The Obama administration was dealing entirely through sub-regulatory guidance, meaning dear colleagues and electronic announcements and enforcement actions, things of that nature. So it really is a false narrative that at least the first Trump administration just kicked everything out. And I think it would be a dangerous assumption to believe that this administration is just going to rescind everything wholesale. I think what you're going to see is a more thoughtful revision reduction. There will be some things I suspect that will be rescinded entirely, but many of these things on this page will probably not be removed entirely. So the point is, it's worth investing the time, we think, to make sure that you're complying and to keep an eye on the guidance that's out there from the department. Some of that may change with this administration as well, but don't forget about this stuff or this stuff. So on July 1st, 2024, we had another whole set of regulations that came along. Now, more of these are currently subject to challenge. The first bucket here you see was the income-driven repayment plans. That's the SAVE plan. Then we had the financial value transparency and gainful employment rule. Then we had a whole lot of rules under financial responsibility, and these are big categorical titles, right? Because there are a lot of little things tucked into this idea of financial responsibility. Certification procedures for Title IV, for example. That's where your professional licensure disclosures and the requirements that students who are, enrolling in your distance education programs, that you have to establish in those states that your program meets those professional licensure requirements. That's all tucked in here under certification procedures for Title IV, standards of administrative capability, state-defined processes for ability to benefit. And then finally, we got a little more that came along. So effective July 1st, 2026, I mentioned earlier, are the distance ed and return to Title IV rules that were just finalized earlier this year. They are subject to the regulatory freeze. You can see that parens. And then we had a host of incomplete rulemaking. So you had student debt relief, or Plan B, and there is a lawsuit that was filed. I checked it today earlier with one of our litigators. He confirmed Plan B, that litigation is still pending. It hasn't been formally withdrawn, but the rule has been withdrawn. It was actually formally withdrawn by the department in December. So we expect that that litigation will just be brought to a close very shortly, since the rule is no longer even out there. But then you had a lot of other things that were out there that the department was working on. There was actually NEGREG was held for all of these topics. And then there was a proposed rule that was put out for the federal TRIO programs. We never actually got to a proposed rule on these other topics, one of which, by the way, you'll see tucked in down there is third-party servicers and related issues. So, we had the big guidance in 2023, I think it was, and then the department said, okay, we're going to do a rule, and they said, we're going to start that rulemaking process. Our expectation, by the way, is everything in this last bucket. We really don't anticipate that this administration would pick up one of those rulemakings and issue rules. We think that'll just all be terminated. And to the extent they want to put together a rulemaking agenda, which we think they will, they'll start from scratch and have a whole new rulemaking agenda. Okay. But all of these things, I was focused a minute ago on the stuff that's still out there. I just want to highlight, all of these things are still on the books. These are different topics, right? And are not currently subject to challenge. There's no litigation out there that's challenging any of these. I just want to go through them briefly. So there were changes to compliance audits and financial statements. Some of you may have been contending with this idea. The department now requires that your fiscal year and tax year end be the same. There were changes to the general standards of financial responsibility. There were changes to the financial responsibility triggers and reporting obligations. Those were quite substantial. That is an affirmative obligation that has been put on institutions as of July 1, 2024. I will highlight, we have a very handy 2-3 page guide we put together that just has all the different financial responsibility triggers under this rule and the deadlines for reporting. There were significant changes to the change in ownership process. For those of you who may be looking at mergers or consolidations or other type of acquisition or transactional activity, how you establish financial responsibility after changes in ownership was changed. There was additional discretion given to the department under the no rules for schools that are on provisional certification, particularly if the department thinks that your school is at the risk of closure. And there's no real clear definition of what that means. But there are rules that went onto the books in July 1, 2024, where the department basically said, if we think you're at risk at closure, we can put you on provisional, and here are all the additional things that we can do. Some of you may recall the department introduced these new supplementary performance measures, which includes an examination of like withdrawal rates and some other type concepts that aren't really fleshed out. And the idea is that the department, when you are going through recertification, can now look at some of these additional performance measures and take them into consideration when deciding whether or not to certify initially or recertify an institution. There's this parent liability rule that's hanging out there that requires parent entities to co-sign the PPA. The professional licensure disclosures I mentioned earlier, as well as the professional licensure program and accreditation, programmatic accreditation requirements that are now embedded in your PPA. The transcript withholding provisions, remember that talked about your ability to withhold transcripts in certain circumstances. Scholarships conditioned on foregoing Title IV, meaning you can't condition scholarships for people on the idea that they would forego aid. There are new conditions for conversion transactions where schools are going from a proprietary to a nonprofit, new requirements for verifying high school diplomas where there may be a doubt about the validity of the high school diploma, requirements for clinical and externship accessibility, adequate career services around misrepresentation and aggressive recruiting, and additional financial aid counseling requirements. None of this is subject to legal challenge right now. These are all effective rules and rules that we think could be revisited and revised, but most of which we doubt will go away in their entirety. So here's the good news. That Appendix A I referenced at the beginning of the presentation that's on the back end of this slide deck goes through all of these topics. And there's almost a slide or two on every one of these topics that tells you a little more about what's going on there. And it's got a citation to the regulation that tells you where to go if you want to learn more. So I hope that is helpful to you all as you recall that all of these new regulatory requirements are out there. This brings us to our second secret word of the day. It is defense. Defense. And you'll see on my screen it is A. So again, if you are a continuing legal education lawyer type, please be sure to click A on your screen so you can get that CLE credit. And then in just a second here, we're going to start talking about the different rules that are subject to legal challenge, particularly a couple of the big frameworks, bar defense to repayment, financial value transparency, and where we think they're likely to go. We're doing pretty well. Top of the hour, we've got a good 30 more minutes. So I think we're in pretty good shape. By the way, I'll just preemptively say, I know one of the comments we frequently get in the surveys is Aaron talks really fast. And I will say that is true, notwithstanding the fact that I'm a native of the state of Louisiana. You would think I would talk more slowly. So I will try to talk more slowly, but when there's so much to say, sometimes it's hard to slow it down. Okay, so let's keep moving, and Aaron will do his best not to talk too fast. Let's discuss first bar defense to repayment. One of these really big regulatory frameworks that's been batted back and forth from one administration to the next, going back to second term Obama administration, and really even, started back during the Clinton administration. So under the HEA, and this is an important point, under the HEA, so this is Congress has done this. They've said, we want the department to articulate those types of defenses that if we're trying to collect money from a borrower, the borrower could raise so that they don't have to pay back their loans. And pursuant to that statutory directive, the department, first way back in 1995 and then back and forth over the last 20 years, has talked about what a student has to do. Right now, students can file a claim, really just an application with the department. So they can just go online, find an application to have their loans discharged, that's direct loans, if generally their institution they think misrepresented or otherwise engaged in some misconduct with regard to the educational services that were provided. If the department discharges the loans, then they retain the right under the law to turn around and try to seek those amounts from the institution, right? So there are real stakes for an institution here. If you get 100 claims and those people, those borrowers across all of them have $2 million in loans that they took out and the department discharges all of them, theoretically, the department could turn around and say, hey, school, you owe us $2 million, right? To date, hundreds of thousands of BDR claims have been filed. And in data release that was by the department pursuant to a FOIA a couple of years ago, back in 2022, indicates that almost every institution in the United States has at least a handful of these claims. We know many of our clients have seen them, private nonprofits, publics, flagships, career schools, everybody's got them. And there are over 500 institutions that have 30 or more. And if you assume, that there are about 5,000 institutions of higher education participating in Title IV these days, maybe a little more, you're talking about somewhere between 7 to 10% have 30 or more claims lodged against them. So it's hundreds of thousands of these claims that are sitting out there. The Biden administration's version of this rule, and what's a little complicated here is, as each administration has come along, their approach has not been to just totally rewrite the prior administration's rule. What they've said is, okay, the Obama administration's rule applies to the loans that were originated, while the Obama administration was around and before the Trump administration got its rule on the books. And then the Trump administration's version applies to loans that originated after the Trump administration's rule became effective. And then now the Biden administration came along and they had a slightly different approach. But the point is, you had all these different versions of the rule sort of coexisting in the law at the same time, which made it terribly confusing, even for the lawyers of the world who eat and sleep this stuff every day, to figure out like what version of these rules and standards and processes apply to a given set of claims. You could even have students who had, took out some loans before one of these, days in the lines in the sand, and then some loans after. And so you had different processes that applied to different loans. It's crazy. Okay. So in February 2023, career colleges and schools of Texas sued the department seeking to invalidate the Biden administration's version of the rule, just the 2022 version of the rule. In the meantime, keep in mind, we've still got a 2016 and a 2019 version of the rule that are on the books. In April 2024, the Court of Appeals for the Fifth Circuit granted a nationwide injunction following several different machinations in court. But as of April 2024, we had a nationwide injunction in place. And as we've stressed again, and I just said this, but that doesn't mean there was no bar defense rule on the books. It meant that the 2022 version the Biden administration created was paused, which meant the department could still move forward in adjudicating claims under the 16 and 19 versions of the rule. But here's where it gets super interesting. If you're a lawyer nerd, I suppose, like me, and I think some of the others may be on the line, on January 10th, the Supreme Court, the department actually petitioned the Supreme Court for cert, meaning under the Biden administration. And on January 10th, the Supreme Court said it would consider whether the department has the authority to process borrower defense claims before a student's actually in default. In other words, Congress said, remember, we want the department to articulate. The department is trying to recover from a student the defenses that borrower, I should say, not student, but that borrower could assert in defense of having to pay back the loan. So what's sort of contemplated there is that the borrower would be in the midst of a process and there's a claim being made on them and they're asserting a defense. But what the Obama administration did was they said, well, we're not going to require a student to actually be in a default proceeding. They can just file an application at any point in time and seek to have their loans discharged if they think the school did them wrong in some way, right? And I understand the policy argument for doing that. Also understand the other policy arguments going the other way, suggesting, well, you're lowering the barrier of entry and you're just inviting folks to try to get the loans discharged, et cetera. A lot of arguments on both sides of this issue. But But what's interesting is the congressional directive and statute really seems to contemplate that this defense would be lodged in the context of a complaint. And what's interesting is the Trump administration raised this during negotiated rulemaking when they put out their proposed rule and said, we want people to comment. But even the Trump administration, Trump 1, eventually agreed that students could just file an application. So every version of this rule allows students to just file an application, at least the 16, 19, and 2022 versions do. What's also interesting is all three versions of the rule allow the department to do the adjudication, meaning like someone, a staffer or someone at the department or an administrative appeals judge, but someone at the department, not an Article 3 court, meaning like a federal court, right? And then finally, the 2016 and 2022 versions also contemplated a group claim process, which sort of looked and felt a lot like a class action. What's fascinating is the Supreme Court is now going to look at all three of these concepts to see if they are authorized and consistent with statutory authorization. And if they were to determine that they were not only could that potentially have consequences for the 2022 version of the rule, but it would also presumably invalidate those same core elements for the prior versions of the rule, right? That, or at least to the extent those elements existed in the prior versions of the rule. So this is super interesting. Meanwhile, earlier this week, the new administration asked the Supreme Court to hold off on reviewing the bar defense piece, indicating, and this was acting Solicitor General saying, after the change of administration, the acting Secretary of Education has determined that the department would like the opportunity, should have the opportunity to reassess the basis for the soundness of ED's bar defense regulations. So reading the tea leaves for BDR, by the way, I had to drink a lot of tea to get tea leaves that formed into this shape. I'll just let you know. Kidding. I'm kidding. AI, what will we do without it? Okay. Here's what we think. We think Congress is going to direct the department in statute to remind. Congress has directed the department in statute to establish bar defenses. So this isn't like, fair financial value transparency, gainful employment, or some of these other things where there's an argument that Congress never told anyone to create this thing. Congress did tell the department to articulate what these defenses should be. And again, even the first Trump administration did not make any effort to eliminate this rule entirely, and we think that would be problematic, again, because Congress has told them to do it. The first Trump administration did, however, again, question whether claims could be assessed before a default, and they acted to remove group claims. So the 2019 version of the rule did not include a group claim concept. So we do not think BDR would be eliminated or will be eliminated. But our expectation is that the current administration will cooperate with the courts to establish, if they can, that these controversial elements, group claims, maybe even adjudication by the department and the application concept are indeed illegal. I think this administration would welcome a decision from the Supreme Court potentially on that front. But without regard to whether they cooperate or the Supreme Court eventually gets there, we think that this administration also will probably pause while the Supreme Court is considering these ideas and cease moving forward with bar defense claims. I think the argument would be the Supreme Court is deciding whether or not these critical ideas are even legal. And so we don't think we should be doing something that could be potentially deemed illegal on a go-forward basis. So we need to pause potentially. And in the meantime, I think they'll initiate a rulemaking process and try to rewrite the bar defense rule. And my expectation would be, particularly if they get cover from the Supreme Court, take out those three elements and winnow it down dramatically from the concept that we've seen previously. And what's interesting is where prior administration, the Trump 1 administration, the Biden administration, sort of felt constrained by the version of this rule that had existed before, a Supreme Court decision in the negative on these three concepts would sort of blow things up so much that I think it would open the door for the Trump 2 administration to significantly revise and winnow down and reshape this in a fundamental way, the bar defense framework. Okay, let's talk about financial value transparency and gainful employment, one of the other really big and consequential regulatory packages we've seen in recent years. I'm going to take 1 second to take a sip. Okay, so on October 10th, 2023, the department published its final financial value transparency and gainful employment rule. Those of you who participated in the process, if you were like me, may have been somewhat frustrated. There was I think there was 1 day of negotiated rulemaking, like really 1 8-hour chunk, even across all 3 weeks. And then institutions had about 30 days to try to digest and comment on the gainful employment rule. I'm just going to call it gainful employment, keep life easy, which was a very short period of time to digest and meaningfully comment on what is an extraordinarily complex regulation. After that, we saw lots and lots of sub-regulatory guidance hitting the newsstands, which, by the way, going back to resource limitations, when the department rolls out these massive regulatory frameworks, that means lots of folks have to be allocated to rewriting and revising and generating all of this sub-regulatory content and the NSLDS handbooks and building the website interfaces and all those kinds of things. Again, I'm hopeful that if some of these things are eliminated, it might ease a little bit of the difficulty at the department and its resource constraints. That may be wishful thinking, but we'll see. This financial value transparency gainful employment rule really was extraordinary in its scope. For starters, as many of you recall, it extends to all of higher education. That is why everybody who participates in Title IV for all their Title IV programs was required to submit all kinds of data to the department. And the department also indicated they're going to build a website and they're going to label all these programs after they crunch the numbers. And if you fall below certain thresholds, low earning or high debt burden labels could apply to your program. And then if you've got a gainful employment program, which is everything offered by proprietary schools and all the non-degree programming offered by everybody else, you could actually lose Title IV eligibility if you fail to hit these thresholds. Right out of the gates, as many expected, the department had difficulties, again, going back to those extreme resource constraints and these issues with subcontractors. First, the department announced on August 30th that it had identified issues with some of the information that it had made available to institutions. And on September 13th, it gave up the ghost on any kind of reporting deadline in 2024 and just said, we want everybody to report everything by January 15th. Many of you allocated many hours to thinking about and pulling together this data to be reported by January 15th. Some of you, I know because you called me, did not. And then in the last 2 weeks pulled it together, and some I don't think ever pulled it together, and we're rolling the dice, right? But my expectation is there was a wide range of reporting behavior out there, and I would probably guess the quality of data reported probably varied quite a bit from one institution to the next. And that is not a dig. It's super complicated. And it was hard to get guidance from the department. Things kept getting pushed back. Completers lists and NSLDS reports were inaccurate. I mean, it was not well run, right? After the January 15th deadline passed, on the final day prior to inauguration, so the 19th, the department announced that it was reopening the reporting process solely for debt reporting until February 18th, 2025. And so now we have a new administration. Since the inauguration, the department's made no announcements, to my knowledge, regarding gainful employment, but I'm sure that there will be things in the works. But let's talk about the litigation. So in December 2023, the Cosmetology School Association, American Association of Cosmetology Schools, filed a suit in the U.S. District Court for the Northern District of Texas. It was later consolidated with another lawsuit. Key idea here, a couple of them. First, on June 20, the court denied plaintiff's motion for preliminary injunction. And that's notable because in a number of these other lawsuits, our defense, the lawsuit around the bare minimum rule, the Plan B and SAVE lawsuits, the courts did grant preliminary injunctions. Here they did not. On July 10th, I mentioned these were consolidated. The briefing was scheduled to be completed. So then we were proceeding to a decision on the merits. The briefings were scheduled to be completed by the end of this week. And on the 27th, earlier this week, I said I hadn't heard anything out of the department. Not quite true. On January 27th, the court granted the department's request for an extension to file a reply brief in support of its cross motion, pushing the deadline to February 14th, 2025. My expectation is, much like the department has asked the Supreme Court for an opportunity to reassess the department's stance on bar defense, that here, this administration wants the opportunity to reassess its stance on this rule, and that will impact the briefing that we see in the coming months. Assuming the department files its reply brief by the due date, the case will then proceed to a decision on the merits. Once again, lots of tea being drunk to get to this, to get to something that spelled out GE. So reading the tea leaves. So we think this administration net does not favor the current GE rule. And I say net because I do think there is some countercurrent. I think this administration, like all these administrations, folks up on the Hill, down in the valley, are interested in your data. And so I think there is to some extent, there are folks coming in who would be very interested in getting all of this data for institutions of higher education. I will also note that in theory, this is a framework that is already in place that could serve as a lever if this administration wanted to put pressure on institutions. particularly regarding certain programs, because here you've got an infrastructure in place, the purpose of which is to measure the value of different kinds of programs. Just think about it. So my expectation is still that this administration on balance does not favor this framework. I think there are many in the party who are coming into this administration who have taken issue with this framework for a very long time. I think that all of your higher education trade associations inside the Beltway are going to be pushing hard for this to be eliminated. But I could see an argument for why this administration might want to hang on to this framework, right? To the extent possible, we anticipate the department, notwithstanding what I just said, ultimately is going to utilize the pending litigation to create cover for delayed implementation. I mean, it was the first Trump administration that held an entire separate negotiated rulemaking to consider gainful employment, and ultimately decided, for a host of reasons that are sitting out there in the Federal Register in the preamble to their final rule, rescinding the Obama administration's gainful employment rule as to why this concept doesn't work, right? So that is still sitting out there and on the record. And that's why we still think these guys are going to break that way. I'll just note that was the approach employed by the first Trump administration. There was litigation there too, and the administration sort of cooperated. The court already was breaking in a direction favorable to plaintiffs in that case and against the department's rule. And ultimately, the department sort of slow-walked implementation, and it used the pending lawsuit to some degree as cover for that slow walk. And we think ultimately that's what's going to happen here again. But just caveat, because I'm a lawyer type, could be some reasons why this administration would break in a different direction. Okay, here's our last secret word of the day. We've got court, and the letter is B on my screen. It's the middle choice, so please, last secret word of the day. If you've hung in with us and you're getting that CLE credit, really hope that you'll take a minute to click on that radio button so that you can get your continuing legal education credits for the year. So again, I'll give you just one more second. And then finally, I want to go through briefly the status of some of the other things that are out there sitting in litigation, a couple of policy documents, and then just get on in questions. So I'll give you just a couple more seconds. Again, please submit, hit the radio button. It's B and it says court if you are looking to get your CLE credit, because we want to make sure that you get that. All right. Let's keep moving. So let's talk about some additional ed rules that are in court right now. I'm not going to talk about Title IX because we already discussed earlier that there already is a final decision on that topic, and we think the 2024 rule is pretty much out of commission. But there are some other things that are out there. First of all, the SAVE plan there's still litigation out there pending. In August, the 8th Circuit Court of Appeals granted a preliminary injunction, which means that they determined that one, likelihood of irreparable harm, among other things, and also likelihood that the plaintiffs would prevail. And they blocked the entire SAVE plan while the legal challenges of the program continued. The Supreme Court declined to lift that injunction. I think the real question here is our expectation is the incoming administration has no interest in this plan, so that they will not seek to pursue this litigation or be successful, right? I think they are going to cooperate with the courts in a way that ultimately will put the SAVE plan permanently to bed. Student debt relief plan B, that's the one that's already been formally withdrawn by the department. So that rule is off the books. And the bare minimum rule, this is the rule, very interesting. The department, as part of that July 1, 2024 package, if you have a gainful employment program, which again is all programs offered by proprietary schools and non-degree programs offered by everybody else, if you have a Title IV gainful employment program, and the state says this is the minimum length for a program of this nature. So cosmetology is a really easy example. In a lot of states, states say the minimum length for a cosmetology program is 1,500 clock hours. Then the Department of Education created a new rule that says, okay, well, that's the maximum length that a program can be. So essentially, institutions offering gainful employment programs where there's a state law with a minimum number of hours for the program have to have a program that equals exactly that minimum number. There was a lawsuit brought in the U.S. District Court for the North District of Texas against, again, there was a preliminary injunction filed there, and the parties are proceeding toward a decision on the merits. And lastly, I want to talk a little bit about incentive comp. Remember this thing back in 2023, the same time the third-party servicer rule was issued, the department, and all of this, the department was very clear in their guidance was about OPMs, online platform managers, program managers. And the notion was not only did they want to classify those OPMs as third parties so they could get them under the third party servicer rules, but they also wanted to get at one of the primary pieces of guidance, not law, guidance in the world that enables a lot of these OPM contracts to exist, or at least their economics to exist. And that's under this 2011 guidance from the department. There's a dear colleague letter where the department basically said, if an online program manager or any service provider is offering a bundle of services, then you can have a rev share model in the agreement. And a lot of service providers use that type of model. It's so interesting, Charlie Rose, former general counsel, U.S. Department of Education, fellow private practicing attorney out there in the world, very knowledgeable guy. I remember right before the Biden administration took office, Charlie and I did a presentation together, and we both thought this was like top of the priority list for the Biden administration. And I think it probably was. I think the issue was they could never ultimately find a way to get at it that didn't seem like it was going to be extraordinarily disruptive and potentially harmful to lots of schools and lots of students. If they just took away this guidance and said, no, all these arrangements are now illegal, all these schools could lose access to their OPMs. And what happens to all those programs that are being supported and all of the students? So that was a complication, I think, really significant one that the department was noodling for a very long time, among others. But I think there was a real desire to do something about this. The department never got to it. But what is interesting is September 17th, 2024, there was a complaint filed by a legal advocacy group in the DC Superior Court challenging the bundled services provider exception. And one thing you'll note about this date, September 17th, it's after Loper Bright. So, it's interesting. A lot of us, the lawyers in the world, I mean, when the Loper Bright and Relentless and Corner Post decisions first hit, I think most of us were thinking about, what types of challenges would be levied against regulations that the Biden administration was creating, right? That were sort of out there in the world or had just arrived. But there also is now opportunity under that sort of combination of Supreme Court cases for folks to challenge rules that the Trump administration created, or for that matter, depending on sort of under corner post. I mean, theoretically, you could have regulations from years and years ago that get challenged. This is not even actually a regulation. I mean, what's interesting is the bundled services provider exception is a piece of guidance. So I'm sure the OPM community is watching this very closely. If you are an institution with meaningful OPM relationships, this is also litigation, you probably want to watch closely. And then finally, I'll just go quickly. If you have questions about all the things we've been talking about, or I've been talking about, if you have questions about the executive orders as they hit in the future, if you want to contact us, you are welcome to reach out to me. But I also wanted to note there are other people at this law firm in our higher education practice who would be delighted to help you out. And we sort of categorize them here. There are more even outside what's on the page, but I couldn't fit everybody on the page. But if you sort of have transactional merger acquisition type questions, regulatory type questions, Scott Goldschmidt does a lot of non-discrimination work for our clients I mentioned earlier. He was quoted in the Wall Street Journal today talking about the DEI executive order. And then Trey Cleveland and Brent Hill are two of our higher education litigators and follow a lot. And I want to actually shout out to Brent and thanks for helping me prepare this and get a lot of the litigation stuff together along with Trey. So please feel free to contact any of those folks. We have lots of compliance materials we've put out there. I just want to highlight the middle one here. It's a little hard to see, but that's the financial responsibility reporting guide. It is free and sitting on our website. By the way, if you pull up these slides and you go to that higher ed resources page, it'll take you right there and all these things are available. Also want to highlight our blog where particularly our litigators, Trey and Brent, some of those guys have just been crazy busy. I think we've got 6 blogs that have gone up in January for reasons you can imagine. But in addition to all those other resources, if you'd like to follow our blog, we'd be delighted. If you'd like us to get our higher ed alerts and things like that, let us know. And then we have on YouTube, our firm has a page and there's a higher ed playlist. And this webinar and everything we do that's recorded is part of that higher education playlist. And again, it's all free. So please feel free if you'd like to check out these resources, or you can just have this one page in your tab and it'll take you to all that stuff. And then finally, just a reminder, here's the appendix. And there's another 25 pages plus in this thing that goes through all of those rules that became effective in July 1, 2024, at least a lot of the significant ones, and includes citations. Okay, so it's 3:24. Let's do some questions. and see. Well, I'll do the best I can. I'm going to scroll back to the beginning. Are you expecting short-term Pell to be enacted in this Congress? So, yeah, I think that is, one of those, piecemeal is the wrong way to put it, but one of those ideas that has been important. You may have seen Linda McMahon is on record as supporting short-term Pell. She's also on record, as is this administration, as wanting to promote short-term programs in general, workforce and technical programs. You may recall the new chief of staff who came over from AFPI in that earlier slide was one of the folks who's her prior life at AFPI, she was working on workforce and career type issues. So I think it is something that Congress is interested in. It is something that could potentially find its way into one of those reconciliation bills. It's not going to help offset the budget cost of tax cuts. So it's not helpful in that way, but I think there is a significant and really bipartisan interest in short-term Pell. And so, yeah, I do think there's a likelihood that we'll see action there. And you should ask Chris Murray, the chair of our lobbying policy practice. He knows that even better than I do. He tracks that stuff more closely. Would the College Cost Reduction Act be eligible for a reconciliation package? Or not the whole thing, right? Because the whole thing kind of represents the Republican wish list. It's their HEA, but as we mentioned on the other slide, there may be pieces of it that they try to pull out and get into like an omnibus or reconciliation bill or something like that and get through. And I think that was what we were trying to get at earlier. But great question. Let's see. Given what you've described about the state of the Department of Ed broadly, what do you think this means for future enforcement actions? Great question. Thank you for that. So what's interesting is the number, the Biden administration was very interested in enforcement, created or reconstituted an enforcement division that had been created under the Obama administration. We saw some actions, worked with some clients who were working with that enforcement unit. But the truth is, exactly for these resource constraints issues, the number of program reviews, for example, which as many of you know, the program review is just the program is the Title IV programs. So that's like the standard means by which the department on an annual basis, goes out and does sort of routine audits and reviews of institutions. Program reviews have been going down, including during the Biden administration. And the reasoning was because there just weren't enough hands on deck. I absolutely think that when you talk about like Title IV enforcement, sort of piecemeal enforcement actions or investigations, that we're going to see a decline. Exceptions to that, enforcement actions that are designed to advance, for example, DEI objectives of this administration. If you look on the newsroom, the Department of Ed's newsroom, they've already announced an investigation of, I think it's a Denver elementary secondary school that has a all gender restroom. And this is clearly, in connection with the DEI priorities of this administration. So I think those types of investigations will continue. I also think to the extent that the department, sometimes, people reach out to the department, students or competitors, other schools, et cetera, and raise significant concerns. So the department, you may see the number of sort of standard annual program reviews going down, and you may see that enforcement unit disbanded. It was disbanded by the first Trump administration and then reconstituted by Biden, so it may be disbanded again. But I still think there would probably be a function within the department if somebody raises like serious concerns or, calls the department and says, here is evidence that this institution is breaking a host of federal laws. I mean, I think the department will have some capacity or interest in continuing to investigate that. That's what I would think. I also think, beyond that, the department will continue to use your annual audits as a means by which to sort of monitor compliance by schools. So to the extent you have your annual independent audit that identifies deficiencies or concerns, the department is still going to have to resolve those processes, right? One would think. Let's see. Are there thoughts, rumors about what the changes with accreditors and/or accreditation will look like? I've heard some rumors, but nothing categorically. I think what the administration sees here in the department, I guess, is accreditors as a potential lever. I mean, there's been rhetoric out of President Trump and the White House about accreditors and their standards advocating for requiring, particularly again, DEI initiatives, things like that. And there's some accreditors in states that actually require institutions to have some level of DEI engagement or programming on campus. And whether that is illegal DEI activity as conceived by the White House, hard to say. But I really see this administration, I don't think their view of accreditors, this is just my take, but I don't think their concern is with like whether accreditors are doing good enough job, ensuring the academic quality and integrity of institutions of higher education. I think they believe accreditors are have been pushing institutions in a direction with regard to sort of the culture stuff, the culture war stuff that this administration dislikes. And so I think they see the accreditors and rewriting these rules around accreditors as a way to prevent accreditors from doing that, and maybe even force accreditors indirectly to require institutions to do, things around DEI and sort of other cultural war concepts that are priorities for this administration. That's categorical, but that's sort of where I think most folks who spend time thinking about these things, I will say, sort of see it going. Let's see. Do you think gainful employment, financial value, transparency are going away? Read the tea leaves earlier, so that one we got to. Should we be concerned that deregulatory actions at the federal level would simply prompt more state regulatory actions to fill the void, giving distance ed providers in particular a more complicated patchwork of laws to navigate? Yes, I think that's 100% true. Now, I don't know if I think that. I think most of your state activity is going to be more along the lines of, I mean, not to say that state authorization and professional licensure aren't viewed through a consumer protection lens by attorney generals and others. They clearly are. But in my mind, I mean, Sarah is there, and the state legislatures have signed on. I think it's going to be a little more challenging for states to totally eviscerate SARA or the reciprocity agreement. But I think what you could see, for example, is, and Massachusetts has this, right, where you have an attorney general that creates consumer protection requirements that apply to institutions of higher education that are outside of the authorization framework. So in other words, the attorney general would say to the institution, I hear that you're in SARA, and that's great. And I'm not saying you have to comply with these to be authorized. I'm just saying you have to comply with these as an institution of higher education doing business in our state, just like you have to comply with other, state requirements if we think that you have a sufficient presence in our state, without regard to whether you are authorized to operate in the state, right? I could see that kind of thing occurring in a lot of states, but taking a big step back, it has been the case over the last 20 years that when the first Trump administration came in and, rolled back gainful employment, you saw California and some other states trying to create sort of state level gainful employment concepts. I think that you will see that if this administration starts pulling back on some of what the states view as consumer protections at the federal level. Yes, I think you will see that. I think you will see AGs suing and challenging every rule that comes out of this department. Will be all the collection of, sort of blue state AGs this time around. Over the last few years, it's been red state AGs suing the Biden administration. And, this is sort of a consequence of as Congress has become less active and the executive agencies have looked to create more through the rulemaking and executive orders, then the counter to that has been multi-state AG lawsuits and courts issuing nationwide injunctions. It's all sort of growing up to balance, and the argument could be made this is all the result of the decreased efficiency of Congress, right? Great question. Let's see. Could you repeat the newsroom resource that Aaron recommends? It's actually called the U.S. Department of Education Newsroom. I think that's what they actually call it. But if you Google U.S. Department of Education press releases or newsroom, I think it'll pop right up. Let's see. Which group was suggested to bookmark in favorites? You guys can go back and look at this slide, but all those trade organizations are good ones. And I think the department's press release. Also, if you are not signed up with FSA or Partner Connect now to get like the department's weekly digest, I would definitely do that. Also strongly recommend signing up. I mean, I love getting from Inside Higher Ed, Politico, the Chronicle. I get daily emails from all of those guys, sort of their digests, as well as some trade organizations. So a lot of good ways you can get those reliable resources coming to you. For the attorneys that are NACUA members, I mean, the NACUA listserv and their materials obviously are excellent as well. Let's see, some of this we talked about. I'm just skipping through. Yeah, here we go. Well, we sort of spoke to this, but as you point out, many of the Biden regulations remain in effect. What are the chances that Trump will have the resources or especially the inclination to enforce them? Yeah, for sure. Great question. Thank you from that person who I know well and respect greatly. As is the case with all the questioners. Yeah, I mean, I absolutely think we're going to have significant challenges here with if the department doesn't have the resources, it just can't move forward, right? And it can be subject to suits. And by the way, some of you may recall the last time gainful employment went around, the Trump 1 administration sort of slow walked implementation, and there was a group of attorney generals that sued them to enforce the gainful employment rule. And what was fascinating in that litigation is the court, this was a Maryland court, determined that that group of states did not have standing to bring the lawsuit. So then the plaintiffs moved to have that decision rescinded because they did not want it to set a precedent, and it was rescinded, interestingly enough, ultimately. So it's tricky business, I think, for AGs to bring lawsuits to force the enforcement. I mean, it's really better, I think, if you've got institutions or something like that, just so they can establish standing. But it is possible to sue an agency. If the department creates rules under the Administrative Procedures Act, and then a subsequent agency just declines to enforce them, that's sort of tantamount to taking those rules off the books without going through the Administrative Procedures Act. So that's the sort of the basis of the lawsuit, trying to compel enforcement. But to the questioner's point, look, if there's no one there, there's no one there, right? And I mean, so it really, I think it's very true. Like when you talk about financial responsibility reporting, like who on the other end of the line at the department is going to be reviewing all these items that are reported by institutions? I don't know. And then that raises the very interesting question, and you should talk to your counsel about this, because Aaron is not giving you legal advice, but it really raises the question, like with regard to financial responsibility reporting, do we report? I'm not advocating willful noncompliance, but I think there's a fair question. If only 5% of institutions are reporting, aren't those going to be the ones that end up getting potentially penalized? I mean, because they're the ones actually raising the red flag. No good deed goes undone, so to speak. Now, subsequent administration could come along, ramp up the department, and go back and look at who's not been reporting. But it is a really fair question. Like, you've got all these reporting requirements and these affirmative notification obligations around professional licensure and state authorization. And if there's nobody at the department enforcing or watching these things, it really makes you wonder, like, what's the value in participating in some of them? Is there a calculated risk here? Again, I'm not giving legal advice, but I think we are entering a period where the department is going to be greatly reduced, and a lot of these regs will be on the books. And I think there is a question around, like, how many of them will be enforced, how will they be enforced, et cetera. That having been said, to the earlier point, the first Trump administration did not get even after it had time to evaluate, think through, and negotiate many of these rules, it did not get rid of them. So I would not assume that this administration is not interested in enforcing all of these rules, at least in some version of it, right? Even if they have reduced staff, if you end up willfully not complying, or if you fall out of compliance, I would not assume that this administration is not going to enforce the rule. It may be piecemeal, but I think that would be a dangerous assumption. All right. Let's see. Somebody asked if this was a Paul Reed Smith behind me, a PRS. It is. Yes, it is. It's a Zach Myers PRS. One of the less expensive ones. Thank you for asking. Let's see. Sorry if I missed it, but the DCL that came out at the last minute of the Biden administration about misrepresentation with third-party servicers, do the tea leaves show that may be revoked are not enforced. Yeah, although I mean, I read that DCL. I heard I won't. Someone else described it as a nothing burger, and I, you know, think that that is a reasonable description to use. I mean, I read that as basically the department saying, "Hey, you can't misrepresent," which is certainly the case and already the case. So I don't know how much interest this department is trying to in really even dealing with that. Candidly, I mean, my read was the prior administration said they were going to put something out about third-party servicers and incentive comp, and they wanted to be able to say that they did, even though I think most of us would agree that it was not the thing that they had suggested that they were going to put out there, right? So I think they sort of put it out on the wire so they could check a box and say, yeah, we did this thing like we said we were going to do it. It's an interesting question. Do you think that the states are equipped to handle higher education effectively and efficiently? I'm not sure what you mean by that question. I mean, you know, first of all, it differs from state to state, right? The infrastructure, the funding, how many people you've got in an agency, the responsibilities that state may have. You know, I think a lot of state agencies right now, if you're talking about higher education, the authorization of higher education, a lot of state agencies have limited staff, just like the U.S. Department of Education does. We do a lot of merger and acquisition work with institutions of higher ed, so we're often working with state agencies to get those sort of complicated transactions reviewed and approved. And many of them will tell us, I mean, they're working very hard, but they'll just tell us, look, we've got 2 people and we've got 6 of these we have to review, and our half of our board is on vacation and we can't get a quorum. And they are also stressed in many different states. So, you know, to that extent, if they are asked to expand their workload or do a great deal more, I think that it would be very challenging. That would be a lot to ask of them. You know, and it has happened before, by the way. I mean, the Biden administration was actually, interestingly enough, I mean, you know, you sort of think about the paradigm of the Democrats wanting, you know, Republicans being for state rights and Democrats wanting to centralize the federal government, et cetera. But the Biden administration was creating a lot of work for states with regard to like how, you know, with the way it was changing some of the different rules and processes. And so they were already feeling some of that additional burden, you know, and of course, like when the Biden administration says, well, you have to go out and make sure that your programs that lead to professional licensure satisfy every state requirement. I mean, all of these professional licensure boards would sometimes have just 1 or 2 people, or sometimes they don't even have someone who's on full-time staff to answer the phone. I mean, you guys know, I'm preaching to the choir, it can be very difficult for these guys to get answers. So I think the states have limited resources. And I think there's no guarantee, certainly, that if we push things to them, there's going to be more funding, they're going to be able to hire more people and handle more responsibility. Some folks who've been around long enough and have enough gray hair may remember the move way back in the 90s to create sort of the whole state spree system. And the whole idea was the federal government was going to push a bunch of extra responsibilities onto the states, and actually pushed out rules to that effect, and it just never materialized. So I guess my answer is I think a lot of states are already stressed, and it would be challenging for them. I'm talking about just higher education, sort of state authorization, professional licensure, not elementary, secondary. But I think a lot of those state authorizing entities would experience a lot of challenge if they were to be asked to do more than they're already doing. I think many of them are already significantly challenged. Let's see. We'll do one more here. I think we're getting close to getting timed out. This is an interesting question. Based on the recent executive actions and rhetoric, how concerned should institutions be about making statements or taking actions that could be viewed as challenging the Trump administration's stance? Yeah, super interesting. Well, I mean, I certainly think institutions have to be very thoughtful about it, particularly in certain areas. I mean, some might argue that that is in part the role of institutions of higher education is to, you know, express views that may be controversial. Certainly, faculty in traditional higher education, you know, and I still hope that higher education is a place for the exchange, sometimes controversial and you know, tense exchange of ideas. I think that is the idea, but practically speaking, you know, it's interesting because I grew up, some of you may know, and I'll leave you on this, but, you know, my father was a career administrator My mother was a career faculty member. And I think sometimes the worldview among these groups, I'm painting with a very broad brush, please don't send me hate mail or email, but the worldview can be different. And I think a lot of people who come from the faculty side and the academic side are thinking very strongly about opinions and the expression of opinions, and feel very strongly that that's part of what higher education is all about. No disagreement. But I also think the administrators want to make sure that they are not targeted and dealing with massive investigations or other issues that ultimately could negatively impact the institution and its students and faculty, right? So I think it's a very challenging question, and I don't have a great answer for you. Certainly, it is my hope that schools will not stop taking positions and making statements that they think are right. Keeping in mind, schools are not monoliths. I mean, you got a lot of different people with a lot of different opinions. But ultimately, I hope schools will still be able to do that. But I also think they're going to have to balance that with practical considerations. And I don't think that is strictly a Trump administration concept, right? I mean, there may be reasons to feel more strongly about it, particularly in certain contexts around DEI and things like that right now. But I think it's always the case that you have to be mindful about making statements that are openly adverse to regulatory priorities that have been expressed by existing legislators or regulators, whether that's at the state level or the federal level or your creditors. So I don't know. The old joke, give me a lawyer, give me a one-handed lawyer, because every lawyer I know says, well, on the one hand this and on the one hand that. And I know I gave you a two-handed answer there. I think it's a complicated situation. So I wish all of you the best in trying to navigate that one. Thank you for tuning in. Keep the faith. You are all doing great work. Higher education in the United States does important things, right? If we can be of help, give us a holler, and please keep a lookout for further information and free information tools, things from us, because we're going to keep trying to put it out there. Until next time, thank you all and be well.